And this particular final session is going to talk about more, less technical, but more, the PDPC enforcement actions. It's going to be delivered by Mr. Wong Onn Chee, Technical Director of Rajah and Tann Technology. He's already on board, but he's just basically testing a few things. So I like to also take this opportunity to talk about data privacy itself. Like I say early this morning, my forte or my expertise is within legal and regulatory compliance. And we ran a lot of data privacy event, in particularly this year with the CCPA, the California Privacy Act, is starting January 2020. And we all know that in 2018, GDPR in May, take effect, and a number of airlines and company was fined a lot of money. I can't remember, 5% or their total revenue or something. And with airline, hotels, data breaches, or anything like that, it's actually concerned a lot of legal and regulatory compliance people, but more so is that legal and regulatory compliance professionals, they are not technical trained, they don't actually have IT background, so they don't really understand what that means is getting consent from the website and get consents from customer, and how do you process this data, where do you store this data, how do you tag this data from a marketing point of view, like today, if we send out, data, who clicked it, etc., this sort of thing. How do we keep safe this data? Most of legal and regulatory compliance, they won't understand it. They just understand that if there is a breach, what do they need to basically do to mitigate it and stuff, that sort of thing. So one of the key highlights between, not sure you guys know, between the key highlight between GDPR and CCPA is that for GDPR, you need to get consent. For people that visit a website, so you see sometimes you say do you accept these cookies and all that stuff, and but for CCPA you actually don't have to get consent. CCPA, business does not need to get consent from user before processing their data, nor does a website need to press consent from a user before selling their data to third party. And that's very strange, okay? That is the two major difference. However, CCPA do need you to provide the opt-out options. So let's just say client opt-out, then yes, you can't use their data. If clients are not opt out, according to the rules, only basically picking bits and pieces to talk about here, you can actually use whatever you like. But however, there is a sentence saying that one of the main rights of CCPA, as well as GDPR, includes right to inform, and you must inform your clients, right to access, and the right for probability. So if you are going to work with your legal team and compliance team and audit team to draft a policy in line with the data privacy policy, it's best to use GDPR and CCPA guideline. Because if you are having a website and you do basically interact with European client, you are subject to GDPR. And for the CCPA, it is a statewide legislation from California. It exempts US state like Nevada, which they also have their own Privacy Act. But because of the major so-called tech company all based in California, so CCPA is going to be quite big. So just happened that because COVID-19 just all really taking place starting late January and drag out to now, those sort of things and stuff like that. Hence, you will be able to see interesting time where people are working from home and how are they going to manage their site, vendors, all sorts of stuff, and monitor their data usage, that sort of thing. The third reason I think the CCPA was enacted is because of the emerge of the data economy, sharing economy. So if you look at a company like Grab, it is a sharing car application per se when it started. But right now it is no longer just, it's a fintech company. It's a payment firm. You can actually pay via Grab Pay, you can order food, you do a lot of things. It's an e-commerce now. So they collect a lot of data. I'm not so sure is Grab subject to GDPR or CCPA because they actually don't operate in either Europe or US. But in the US or in the lot of economy, it is basically based on the data economy and sharing economy, and these two legislations is coming up. And how does it affect all the companies that are in this particular model, especially with financial services, that you open your API for payment company? This will basically applies to you. For payment company, for e-commerce, any company with website that interact in sharing data, this will applies to you. Less applies to manufacturing unless you sell it online. And obviously, it applies to government agency, in particularly, right now, also applies to healthcare, where people are getting tested and checked or anything like that. With the times like that, the priority are not looking into their cybersecurity, IT in hospital, healthcare, etc., insurance. Priority is actually get people tested, the well-being, the health of the citizens, and that sort of things. And they are going to be exploited on this kind of thing. And people will be basically using these data and stuff. This year alone, I changed 3 credit cards. I don't know what happened. Obviously, I fly a lot, and different airline uses my credential, and obviously I use credit card to buy all these flight tickets and stuff. I have to change my AE 3 times. Each time is a month afterwards. There are some strange transactions that saying that I buy lots of jewelry. As you know that I don't actually wear anything, any jewelries whatsoever, and those sort of things and stuff. And this basically prompted, the statements comes in, and it's like, my other half is asking, oh my God, you're buying all this jewelry for who? I'm not getting it, and some of that sort of thing. That's that created a lot of confusion. The second time is also jewelry and women's clothing. I swear to God, I am no, I don't wear women's clothing. And the third time is the same, and that sort of things and stuff. So, my data I keep being sold to a lot of other places I don't even know now. I just got a news that Mr. Wong needs to change the laptop because they have problem logging in. So we just have to wait for 5 minutes. Again, I welcome everyone that basically joined this particular webinar. If you have best practices to share on how to secure your data, data privacy, compliance policy, etc., do give a hand raise. I'm actually happy to invite you on the screen, and we can have a bit of chat to talk about best practices or whatever you like to talk about in terms of data security. I'm almost running out of things to say about GDPR and CCPA. I can talk all day on this too, but the issue is that things I like to highlight was that, that is the only point, but I think that actually stands out. CCPA is actually more, I would say, it's literally personal. It's actually very consumer driven. So you will get sued. So company in US, or if your company is doing business in US, or you actually interact with US consumer, you need to look out for it. Okay? So if they didn't give you consent and they opt out and you end up basically using their data, or they find out you leaked their data, anything like that, you're in a long haul. That is the scary part of CCPA. But GDPR is more, they will prosecute firm instead of individual coming and sue you or something. So that is the only two things that I see that is caught my eye. But the rest of it is actually very similar to GDPR and such. All right. Let me ask, where is Mr. Wong? Mr. Wong is logging in soon. He's getting his password. Just want to keep you up to date. Oh yeah, Mr. Wong, I can't hear you. I can see you typing there. We do have to invite you into the screen. So Christine is going to invite you into the screen now. Christine, if you're there, please invite Mr. Wong. There you go.
Hi, thank you. Yeah.
Okay, I just spent 11 minutes talking about GDPR and CCPA, so you don't have to talk about that anymore.
Okay. Again, apologies everyone for the technical delay. Yeah. So
this thing happened. Okay, so again, welcome. Mr. Wong is actually a technical director for Rajah and Tann Technology. And you know, Rajah and Tann Technology is actually a spin-off of Rajah and Tann Legal. So the two separate different companies. I believe that Rajah and Tann Technology directly deal with forensic investigations, legal technology, and obviously data security, and now cybersecurity. You guys are also working with a lot of cybersecurity professionals. And I know your COO, Michael Liu, for the last 12 years or so, working very closely on some of the investigation matter on cybersecurity. But also at the same time is that Wong, you yourself advocate on data privacy. You are in several council and committee itself. So without further ado, I'll pass it on to you to basically wow our audience what you have in store for them today. Thank you.
Okay, thank you, Jeffrey. Again, let me convey my sincerest apologies for the delay for everyone in the webinar. So yes, a short brief, perhaps no more than a minute. Yeah, Rajah and Tann Technologies is a subsidiary of Rajah and Tann, the largest legal alliance across Asia. Now, so as what Jeffrey had mentioned, we focus primarily on the technical aspect. So with regards to things like the legal technology solutions for the legal professionals, we also touch on the data breach and incident response services to augment our legal partners in terms of responding to data breaches, because they are frequently asked upon when customers suffer data breaches. Actually, now of course other aspects are e-discovery, forensics, and of course even to the extent of e-learning. So we do have also a virtual learning platform. So without further ado, let me just share my screen. Let me see, where can I share my screen? So hold on. Yes, they're supposed to share screen. Application window, this is the one. Yes. Everyone see the screen?
Yeah, we can see your screen. Go ahead.
So wonderful, great. So, so my topic today is on the analysis of the common causes for the PDPA enforcement actions. So without further ado, I'll skip this because we have touched on this, so I'll skip this. Let's go straight into the analysis of the PDPA violations. The cases that I'm going to touch upon is up to the end of 2019. So 2020 is not over yet, so we won't touch on 2020 cases then. So first off, the breach of data protection is actually the #1 most common type of PDPA violations. Actually, if you look at the chart on the right side of the slides, it takes up to 84% of the enforcement actions that PDPC have taken were related to the breach of protection. And the second, in the race is, if we call it a race, is the breach of consent, right? And if you measure the gap between the first and the second, is as wide as 7 times, 700% between the protection and the consent, right? Next, interesting insight into the actual reported enforcement cases. Now, which sector? I'm not sure about the profile of the audience today in the webinar. The #1 most guilty sector is in IT. Now, this is not surprising because most of the IT vendors process huge amount of data, and that of course include personal data. Then next in line is the financial sector players. Again, not surprising because they again process and perhaps manage huge amount of personal data for the clients. So I think we have a tie between the retail and the education for the third place. Okay, so so the first, of course, the IT. We have the 24 cases against IT vendors for data breaches. 15 in financial, 11 for both the retail and education. Right. Next interesting insight. How about the penalties amount? Now, IT took up the huge chunk. Now, as you know, IHIS is the IT arm of the Singapore public healthcare, what I call that place, right? Namely the polyclinics and hospitals. So they do fall into the IT category. Then healthcare actually ranked 2. I think all of us have heard about the huge amount of fines, 750,000 for IHIS and 250,000 for SingHealth. And if you look at the figure against the IT sector players, it amounts to 948,000. So out of which a lion's share came from the 750,000 fine against SingHealth, against IHIS. My apologies. And of course, the next is healthcare. Again, majority comes from the SingHealth fine. But what's interesting, if you look at the financial and the transport sector, so they rank in terms of the content amount of penalty fines. They actually rank between the 3rd and 4th place. Okay. Now, what are the likely causes of so-called breach of protection? And we dissect further into it. You can see the leakage from web portals, your online services, your online web portals, your online e-services actually account for the #1 most popular or most common source of personal data leakage. Okay, and they were penalized by PDPC. And if you again compare the first, the Billboard top #1 case in terms of channel versus the second, we are talking about at least 300%, rather 3 times more than the second. In this case, will be the PayPal. So majority of the breach of protection principle actually arises from the breach or rather the leakage from websites. So I think it behooves us to actually look at what is lacking today in our protection for our company, our organization's e-services online. Okay. So some interesting decisions, or grounds of decisions that's publicized by PDPC. In this case, the as you can see, this is the case against the SingHealth IHIS, and they make very interesting comment about that an organization needs an all-round security. It's not just about having firewalls or network devices and so on and so forth. They say, I'm enough, right? I'm safe. So these are some of the interesting grounds for decisions. Well, if you have been doing a regular VA, PT, risk assessment, even code review, automated code reviews, well, the bad news in this case is it's still not sufficient. Again, this is one of the, in this case, is against Com Gateway, which is I would say call it online retail e-aggregator, where you can actually go online and purchase stuff from Amazon and whatnot and can ship over via Com Gateway. In this case, the PDPC found them to be, even though they have been performing regular vulnerability scans, penetration testing, risk assessment, and automated code reviews, on their own, it is still not sufficient because it did not address the loophole that that resulted in the leakage of personal data, right? So again, it doesn't mean you have done all this, you are safe from PDPC angle. No, that's not enough. So we have gone through the cases about the, or rather we went through the insights in terms of the cases that were enforced by PDPC. So we went through which are the likely most popular or the most common breach, which principle was most commonly breached, which sector by the frequency of the enforcement cases, and which sector has highest amount of fines, and of course which is the most popular channel of data leakage, right? So now let's dive into what's next then. Now I've gotten the insight into what the problem is. How can I then help the organization that I'm working in to prevent or even to mitigate the risk of this happening? Now let's go straight into the forming causes first. Now, as you know, protection principle is the #1 case. If you look at the first point, with regards to the protection against data leakage from websites, we'll touch on that in subsequent slides, so we won't cover in this slide. Printed documents, one of the recommended control is really to put in additional human check before you ship out the printed document. Now, of course, if you have outsourced it to a vendor to do printing and for postage out, it could be the statement printers, for example. You should ask whether the outsourced vendor have some form of a digital hash check, such that if the information that's pertaining to a client A, okay, could that be wrongly tagged or attached to the address for client B? Right. This is a form of hash check to allow you to ensure that there's no cross-matching of personal data. Then the third most so-called common breach of a protection principle with regards to email. So in this case, organizations should actually explore the use of data leakage protection solutions or data loss protection solutions. My personal preference is called data leakage protection, right? And there are available solutions out there in the market. I prefer not to go into the brand names, but there are available solutions out there to protect or to even to detect data leakage from emails. So will address the top three breaches of protection principle. Now, let's look at the next on the right, the consent principle. Here, some of the main salient points that you can look at is ensure that you have actually clear and explicit consent, right, that you have obtained from the customers itself, from the individuals. Preferably it's either a written form or digital form. Verbal form is not recommended. So if a client verbally inform you that, okay, I'll give you the consent, it would be better if you can capture that in a written or digital form. Okay. Now, second point is the scope of consent has to reasonably match the services or the goods that you intend to provide. So you cannot say I am going to offer service A, and you're asking the client or the individual to give you consent for service A, B, C, D, E. The scope will be too wide and it doesn't match the services that you're providing. So it would feel the reasonableness test actually. Then third point, if you do intend to have what we call the opt-out approach, where everyone is opt-in by default, that itself in the eyes of PDPC is not consent. Okay, so try not to adopt those approach where everyone is opt-in unless the user explicitly opts it out. So that is not acceptable form of consent to PDPC. Okay, just be aware of that. Now the third principle used to be called openness and it has now been renamed as accountability principle. Is where we actually look at whether you have a proper data protection regime within your organization. Now that starts off with you appointing a DPO or a number of DPOs, right? Depending on how large your organization is. Just take note, DPO can potentially be outsourced or in-sourced. So depending on your availability of expertise within the organization. Second point, to develop clear data protection principles and to actually communicate these principles, these policies, sorry, to everyone in your company. Okay, so then three, obviously, is to implement right procedures, practices, SOPs that can effectively protect the data. For example, informing everyone in the staff to say, do not copy any personal data into your personal devices, so on and so forth. Do not share all this thing on social media and so on and so forth. So it has to be effective, right? Practices that that the users, your staff can actually comply with, and that you actually can have oversight. And that brings us to point 4. You do have to review the effectiveness of your data protection practices. So it's not just a case where you just implement the solution and forget about it, and you do not assess how robust the protection is. Okay. Let's move on to the fourth principle that come for the top 4 causes of breach. So it was used to call a purpose principle, and it's now being renamed as a notification principle. So in this case, you will have to actually inform customer clearly about the purpose of the collection, the use, and the disclosure. A bit similar to the consent, but over here we are just expanding it from just a consent to you having to communicate clearly to the client, to the individual. How do you intend to collect the data, or what do you intend to collect? What are you going to intend to do with the data that you have collected, and who do you intend to disclose the personal data to? It could be your outsourced vendor, it could be your marketing vendor. So preferably, again, your written or digital communication would be preferred rather than verbal. Okay. Then the second point in that is if you do intend to pass any data to any third-party vendors, their suppliers, please clearly state that upfront to the client, and also explain to them the reasons for doing that. So it could be for marketing purposes, to run marketing events, to run promotional events, so on and so forth. I believe your clients will be able to understand, right? So that accounts for the recommendations for the top 4 causes of breaches. Let's move on to the subsequent slide. How about the number 1 channel of breach, which is the data leakage from web, from your online services, from your cloud portals, right? So let's start off with perhaps the first recommendation. You should inspect all outbound traffic from your web, right? Because as this entry, as you can read from the slide, the century-old adage where wherever you cannot monitor, you can't manage, and wherever you can't manage, you can't control. Which means when data leak occurs from your e-portal, from your online services, you wouldn't be able to know when it happened, and hence you wouldn't be able to block it when it's happening, right? So it is very important, of utmost importance, that you inspect all outbound traffic from your web or your online services, or even APIs. For folks, among the audience, you have mobile services. Most of your mobile services will connect to the backend via APIs, and your APIs is akin to a web portal, less the graphical component. So data leakage could also occur from there. And there are cases that will the PDPC enforce against. The famous one will be Singtel, right? So the data leakage occur from the backend server API that's supporting the My Singtel mobile app. Now, of course, the second point, right? Expand the data leakage protection that you may have put in place today for the user endpoints, right? For your laptops, for your PCs, to cover your online services. Okay. For those who are in financial sector, I think you are perhaps familiar with the MAS TRMG and MAS regulations with regards to the need to have a data loss or data leakage protection. So again, a majority of effort, focus all these years has been on the user endpoint. Very little has been put upon the online services. And yet, for the PDPC enforced cases, we can see that the leakage for online services account for the highest number of enforcement actions. So wow. So are we being blindsided? Have we been looking at the wrong area? Okay, food for thought. Next, of course, to the right, point 2, right? Secure software development, because a lot of the enforcement cases against data leakage from web portals arise from software vulnerabilities. Okay, I would say roughly 60 to 70% of the leakage from web are due to web application vulnerability, and the remaining portions is due to negligence in configurations. So I'll put the percentage in that manner. So what do you do then with a secure software development? Well, first point, adopt DevSecOps, right? Development security operations, DevSecOps best practices that will allow you to actually secure your codes even when it's actually doing the development, or what we call the shift left approach. So from development all the way to it going to production, security controls or practices should be present throughout the whole life cycle. Now you may ask, why if I outsource my software development? That's where point 2 comes in. Now in this case, if you do outsource your software development, you should ensure that the outsourced vendor that you engage actually practices secure development. And you can actually verify that by asking for artifacts or evidence of them complying to secure software development, perhaps secure software designs, source code review reports, security testing reports, for example, or even the defects tracking reports, the bug tracking reports that they may be using. That demonstrate that the vendor is actually exercising due diligence and on the quality and on the security of the codes that they are delivering to you. Okay. Now, third point, multi-layer defense, right? And that's where we talk about the network defenses, right? Despite what I mentioned earlier about the firewall is not enough, this is not enough, but the firewall is a cog in the wheel where you can't ignore, and it should form as part of the layer defense that a multi-layer defense that you should be proposing for your organization. In this case, one of the key value about layer defense or network-based defenses is that it can perhaps enable you to protect the application that may be vulnerable, and it may not have any existing patch available for you to fix the hole, and aka what we call zero-day software vulnerabilities. So having a network-based defense give you the option to address a zero-day vulnerability before your software patch comes in or is being released for you to address the vulnerability. So you have that option. Point 4, real-time monitoring and response. Our recommendation is you should appoint a team, whether it's in-source or outsource, right, to monitor the state of your web, to ensure that if your website is ever leaking data, or you can even extend this to even cover dark web if you do have the budget, to monitor dark web for any presence of your data being floating out there. In this case, it's basically checking the state of your website to make sure that it is not malfunctioning, it's not spitting out tons of personal data without your knowledge. That's one. And of course, in that aspect, when you're talking about monitoring, you should aim for monitoring. Because today, in the internet world, in the social media era, allowing your personal data to be leaked out and detecting it 5 minutes later, and then stopping it 5 minutes later, hardly qualifies as a proper defense. Just like today, you will not accept any firewalls that there's let's talk about inbound firewalls that block the attacks once every 5 minutes. You can't expect the regulator to accept a monitoring that works once every 5 minutes. That, I think, won't pass muster for any regulator out there as being sufficient and being effective in monitoring and responding to data breaches. Okay. So that's primarily all for my presentation. I hope I have not overshot the time. Apologies for running late in connecting, and just need to show this disclaimer as what Jeffrey has mentioned. We are not the law firm, so I'm not a lawyer, so I can't offer any legal advice. And that's our contact information. That's my mobile and that's my email address. Again, thank you very much. I hope I think it's Q&A time, right, Jeffrey?
Yeah, that's right, Mr. Wong. Thank you so much for the presentation. We do have one question here from Abdu. I can't. I don't have the visibility for a full name. Regarding legal information, he was saying that as an IT director or IT person, how much do I need to know legal in terms of legal information in data privacy? Do you want to take that, Mr. Wong?
Okay.
I will basically add it to it as well.
Okay. So thank you very much, Jeffrey. Yes, that's a very interesting question. How much legal information do you need to know as an IT professional? My short answer to that is enough for you to stay out of jail, right? So as per the recent, I think Malaysia, they call it MCO regulations. In Singapore, we have the stay-home notice and the social distancing. I'm just trying to use a non-IT example, a non-legal example. So in this case, even though I'm not a healthcare professional, but being a member of the public, I need to know enough what the regulators expect, what the government expects us to do. Enough for me to know that, I don't just sit beside a friend of mine, in less than 1 meter apart, and that may, violate certain regulations. But I also need to know enough that the rule doesn't forbid my family to sit just next to me. So I don't need to tell my wife, darling, you have to sit on the next table, because that's what the government tells me, right? So I would say enough for you to stay out of jail. Now, you do not need to be a guru in the legal affairs. Please always consult a proper lawyer, a professional lawyer. But I would say please know enough what the law expects you to do, and the protection aspect as an IT professional or IT security professional, so that you will not be deemed as negligent from the PDPC angle. Okay, I do see some chats, some questions being asked in the chat.
I actually want to basically do a Q&A with you, actually, Mr. Wong. So here's the thing, if you, I know a few people that run the or in the PDPC. One of them is a good friend of mine. I think he's the assistant commissioner. I think a year back, he was telling me that they actually will look at each case personally. So to answer your question, Muhammad, about how much IT people would need to know about legal, to be fair, I don't think you're going to be able to understand the full extent of the rules and law and everything like that. It's very, very comprehensive. And you don't. And for some company that just operate in Singapore, yes, you can just look at the PDPC. But for some company, you operate not just in Singapore, in Southeast Asia, and in particular the Philippines, and also US and Europe have their own data privacy thing, and they're all fairly similar, but they're some are different. So the judge will always look at, have you done enough? Did you purposely do it just to trap people, like what you just say, that you did the compulsory opt-in so that the consumer doesn't know, meaning that you can actually use their data, but in fact the consumer doesn't have a choice to opt-in or opt-out. Is that fair to say, Mr. Wong?
Right. Yes. I think, as you rightly pointed out, that we have different regulatory regimes across even ASEAN itself. Very interesting point about the Philippines law is the DPA law. The penalty is jail and fine. So the judge cannot offer you a fine. They must jail you if you are guilty. So it is it's an interesting point where I talk to my Filipino counterparts. Is there a typo in the act? So now coming back to this, for PDPA, it is actually, if you look at all the principles in the act, the section on the protection is the shortest, but yet it resulted in the highest number of enforcement actions. So it behooves us to actually look at, so what is PDPC looking for in the protection principle? The interesting thing, they have issued some guidelines. Some are sectorial guidelines, some are generic guidelines for across all sectors. And the part about the protection principle, there's some common guidelines listed there. You must encrypt, you must, as much as possible, do your two-factor, proper access control, blah, blah, blah. But as you rightly pointed out, every case is unique. You could have actually done whatever that is listed in the PDPC guidelines, and yet a breach still occur due to a negligence in somewhere during the value chain, and hence resulted in personal data being leaked. Now, in such a case, PDPC, as what you've seen from the slide, PDPC will still go after the organization for negligence. So I was also talking to PDPC, my friends in PDPC, and asking, why don't you give them a master list of to-do list, right? So once I'm compliant, I'm safe. But
no.
They are not going to be hand-bound to say, okay, I've complied all this, and that will be my get-out-of-jail card. So so PDPC intentionally keep it open-ended. So I would say, if you have done your proper risk assessment, you have identified your data flows, and most organizations we have been to, we ask them, do you know where the personal data coming in from, how's it being processed, and where is it being kept or transmitted? And most organizations do not even have the personal data flow mapped. So that is a clear-cut sign that you have not done your due diligence. Yeah.
I mean, you're right. But guys, we need to understand that the law enforcement agency is true. They are out there proactive. They will basically check your website. They will see vulnerability. They will test it. They will see if you actually do all sorts of stuff that you should be doing to protect the data. But when it comes to prosecution, that's not a different story, because that is also depends on the judge itself. That's actually from the legal point of view. That this is where, coming back from Muhammad again, that is where I don't think you need to basically so worry about the legal perspective, because when you go to the court, most of the thing is that the judge will ask you, why are we here? Have you done enough? They actually really look at, you really didn't done enough. But yes, you're right. You are negligent in some parts. Purposely, careless, or you just don't care. And it's basically, if they basically can prove that you don't care and you did this purposely, yes, you're going to get a big fine. But if it's a human error, they might basically let you off the first time.
That's true.
That is a lot of case, but you get a warning, okay? So again, you should basically be cautious, but in terms of legal and regulatory, work with your legal team, work with the law firms that understand the policy. Otherwise, you will get more trouble than this.
We do see a challenge among SMEs. Actually, without disclosing the identity of the clients that we're working with, we come across cases where the SMEs, the business owner, which is totally non-IT trained professional, he could be in other fields of profession. But when data breach occur, they resulted in a leakage of personal data that will actually cause harm to the individual that's affected. In that situation, PDPC, again, it's not announced yet, but the preliminary amount of fines that they're putting forth to the let's say the plaintiff, right, or the defendant in this case, right, is quite high actually. So we do foresee to see potentially higher number quantum of fines against even SMEs. And some of the grounds of judgments that they have put forth is primarily related to negligence or even ignorance of the act. That you do not know that when you engage, let's say, you could be SME business owner, you engage another IT firm to actually your e-commerce website, for example. Have you ensured that the agreement, the contract, what do call it, ensure that the IT vendors complies with PDPA? So all these things you need to be aware, because in the eyes of law, ignorance is not a defense. Yeah.
That's right. Ignorance or negligence. Last question here. For some B2B business, most of the data privacy will be on HR. Not exactly, but on HR and vendor record. Does the organization need to go through the same scrutiny? I would say yes. If your HR, if someone stole your HR data, which contain salary, address, where they live, health report, etc., and everything, depending on how detailed. Financial services is actually very skeptical for this, because some of the financial services, they even basically go through to how much or what these individual, especially trading manager, what do they trade on, etc., and this sort of thing. And if these are out and they can't get a job anymore, the employee can come back and sue you for
Yeah. So as what Jeffrey mentioned is correct. So for HR data is what I call that deemed personal data in the Act. So there are certain principles do not apply to the HR data. For example, the consent to use it, you perhaps don't need to have explicit consent because it's your staff, right? The staff join the company, assign the employment letter or call it a slavery contract, whatever you call it. That itself is a consent for the organization to use the staff personal data, right? Be it for career development, personnel development, professional development purposes, training, and so on and so forth. So the consent part may not be that much of an issue, but when again come back to protection, right? We have seen companies that outsource the HR to the SaaS providers, the cloud SaaS providers, and tons of the HR data may be leaked from the SaaS provider. Now, in that situation, again, subject to the fact case of each individual case, the organization may be found to be negligent if, let's say, when they engage the SaaS vendor, the HR SaaS vendor, there's no requirement for the SaaS vendor, the HR SaaS vendor to comply to PDPA. You did not assess or did not obtain assurance from the SaaS vendor that they are secure, they have some form of security certification or data. And in Singapore, we have the data trust mark, right? So all this would actually smack of negligence or lack of diligence, in this case negligence, in your vendor selection. So that could may result in fines against the organization. So yeah, HR data, it is still protected under the Act, just that certain principles do not apply to it. Protection still apply.
Yeah. All right, thank you so much for this particular segment and the final segment. I found it interesting. It's actually the topic dear to my heart, data privacy. Thank you, Mr. Wong, and also say thank you to Michael as well to agree for you to come on board.
Thank you very much.
If you guys have any questions for Mr. Wong, you're welcome to email him. And you can find him on LinkedIn or anywhere else, that sort of thing, or you can basically send us an email.
I can type in the chat here. Yeah, I'll just type in the chat. So if you have any questions, feel free to send it to me. So that's my email address, rttechlaw, easy to remember, short and sweet. So yeah, I hope everyone have a safe both in cyber and a physical sense, well-being during this period. Yeah, hope everyone stays safe though. Yeah.
Thank you so much, everyone. Thank you for joining us this morning.
Jeffrey.
I see some familiar names there in the area. Thank you, Mr. Wong. Bye-bye.
Bye.